cancer, male pattern baldness, teeth whitening, or a gym membership, which just promotes the general well-being of the taxpayer. And those are contrasted with medical procedures that are thought to produce a change in functioning. Interestingly, the cost of a wig for a cancer patient who's lost her hair is treated as medical care, despite the fact that the wig is put on for the sake of appearance. Vision correction surgery changes visual functioning, so the service has ruled that that is deductible medical care. Weight loss programs that are medically supervised for obesity are treated as medical care because obesity is recognized as a disease. Breast augmentation is exactly the sort of care that was targeted by the cosmetic surgery amendment. That sort of care is not medical care, yet the legislative history of the cosmetic surgery amendment makes clear that breast reconstruction following cancer treatment is not cosmetic surgery and is deductible medical care. The cost of a prosthesis is thought to be medical care because it restores functioning. And we have a lot of rulings in cases in the reproductive and procreative area. We have rulings after Roe v. Wade on every form of reproductive care, abortion, vasectomy, tubal ligation, and so on, all treated as medical care by the service, although those rulings are called into question by a recent case, the Magdalene case. And we have rulings on assisted reproductive technologies. The service issued an administrative pronouncement that said that taxpayers could deduct the cost of IVF and egg donor to, quote, overcome your inability to have children. So that was acknowledged in publication 502, yet when a gay man tried to deduct those costs, the service disallowed those costs in the Magdalene case. And I'd like to talk about Magdalene, we won't have time. It kind of goes with the next panel, actually, so I'd be happy to talk to anyone about it at the end of the day. And then the last item here is the one we're going to focus on, and that is hormone treatment and sex reassignment surgery for GID. And that is the subject of a recent tax court case, the O'Donovan case. And before we proceed to the case, I'd just like to note the obvious, that legal rules, social norms, and medicine all interact, that medical clinicians play a role in the tax law classification of costs as either medical or cosmetic, and legal norms and rules create incentives to treat certain conditions, for example, infertility, or some might call it dysfertility, and gender identity disorder as pathological and medical, to provide additional funding for these procedures, many of which are expensive. Social norms also come into play. So unfortunately we have to skip Magdalene. Again, I'd be happy to talk to you about that individually, and we'll proceed directly to a discussion of the O'Donovan case. First, the facts. Rhiannon O'Donovan was diagnosed with GID per DSM-IV and transitioned from male to female. The taxpayer was treated according to the Harry Benjamin triadic standards of care, first with feminizing hormones, second, the real-life test living as a woman, and third, with genital sex reassignment surgery. The taxpayer also had breast surgery to make her breasts look more feminine, and they were augmented as well following the hormone treatment. The taxpayer deducted the cost of the hormones, sex reassignment surgery, and breast surgery. The service disallowed all of the expenses. And the service made much of the fact that the taxpayer also had a number of other surgeries performed by plastic surgeons, for example, a trach shave, during years that were not at issue in the case, to make herself appear more feminine. Okay, so before we go on to the opinion, I just want to note some unusual aspects of the O'Donovan case. An army of lawyers worked on the case for years, an army of government lawyers, an army of lawyers representing the taxpayer. I have to confess that I made a serious error in judgment. Early in the litigation, I spoke to the lawyers representing the taxpayer from GLAD, and I said, this is an easy case. the statute is written in the disjunctive. If GID is a disease, you're done. Number one. Number two, even if you think that GID is not a disease, I can't imagine anything that changes functioning more than changing a penis into a vagina. So I don't really see how the service is going to win. But it wasn't an easy case from the perspective of the tax court. The case had a high media profile. The trial court transcripts and expert witness testimony total about 1,000 pages. So this litigation just trailed on for years and years and was hotly contested. Another strange thing is one of the taxpayers' expert witnesses was a forensic psychiatrist who usually testifies in criminal trials about the responsibility and culpability of, an alleged criminal for, acts committed. Years elapsed between the trial in the case and the tax court decision, and the decision is what we tax types call a reviewed decision. So instead of the opinion being issued by the trial court judge, Judge Gale, all the tax court judges had to weigh in on the opinion. So the opinion in the case reads like a Supreme Court opinion. It's extremely lengthy with majority, concurrences, dissents, partial, these are all unusual aspects of the case. The majority opinion holds that the term medical care includes the genital sex reassignment surgery to treat or mitigate GID. The IRS disagrees with that conclusion. The majority said that the term medical care includes the feminizing hormones. IRS disagrees. And the majority held that the cost of the breast surgery were cosmetic surgery, were not medical care. Why? Because the hormone treatment had created size B cup breasts, and the court thought that was probably adequate to appear to be a woman. Notwithstanding the fact that the plastic surgeon testified that they looked like B cup breasts pasted on a man's chest. And the plastic surgeon said part of what we did was make the chest appear more feminine, and while we were at it, we increased the size of the breast. So the court said that those costs were not deductible. The IRS agrees with that. And dissents concluded that sex reassignment surgery is not medical care. Why? Because it's directed at changing, quote, appearance, and does not treat the mental condition of GID. And I note here that GID is currently classified with mental disorders, but that's very controversial. Some people think there should be no disorder called GID, but of course that means that it would be harder to classify the surgery as medical care. And some people think it should be treated as a physical disorder because it is a form of dysmorphia. And the third part of triadic treatment is to change the body. Now the IRS made a series of overt arguments in the case, and then there's the covert agenda. And I'll zip through these because these are technical and I want to get to the covert agenda. The IRS said that GID is not a disease, that listing something in the DSM doesn't make it a disease. And then Dr. Dietz, the forensic psychiatrist, says something that I found absolutely stunning as a person who's studied this section for a long time. Dr. Dietz said a finding of, quote, disease requires a known pathology or disease etiology, which is so narrow, I just can't even believe that the IRS let him make that argument. In effect, Dr. Dietz was saying, we need something besides deviant behavior for which the patient should be held responsible. So the IRS is attempting to classify GID as sexually deviant behavior, not a disorder, not a disease. And the IRS said that the taxpayer didn't prove medical necessity or cost effectiveness, but that's never been required. So what's the covert agenda? The IRS stereotype transgender persons as sexually deviant others. The IRS agenda is similar to the approach in this odd ADA exclusion for GID. The ADA provides that the term, quote, disability does not include quote, transvestism, transsexualism, pedophilia, exhibitionism, voyeurism, GIDs not resulting from physical impairments, or other sexual behavior disorders. So one of the purposes of the ADA was to classify HIV/AIDS as a disability, but that led conservative legislators to oppose the bill. For example, one member of Congress stated, the ADA is a last-ditch attempt of the remorseless sodomy lobby to achieve its national agenda before the impending decimation of AIDS destroys its political clout. Their bill simply must be stopped. There will be no second chance for normal America if the ADA is passed. Of course, the bill did pass, but the political compromise was that this list of, quote, sexually deviant behaviors were excluded from the definition of disability. So the IRS and O'Donovan took the position that GID is a sexual behavior disorder, not a disease. But here I want to note that the need for sex reassignment surgery is, at least in part, created by legal rules that divide sexes into binary male-female classifications in ways that affect a person's dignity. Driver's license, birth certificate, passports, are you going to be searched when you try and board a plane? Which restroom do you use? Who can you marry? And so on. So in my paper, I'm drawing a distinction between medical necessity and legal necessity or social necessity that is created by legal rules. And I just want to note here the work of Martha Nussbaum because, behind the IRS arguments is this attitude of disgust towards transgendered person. And I think Nussbaum's distinction between so-called primary objects of disgust, for example, feces, urine, those sorts of things, and what she calls objects of, quote, projective disgust is highly relevant here. Projective disgust is an irrational heuristic that associates a group of people, typically a subordinated group of people, with primary objects of disgust, and usually imputes purity to the person holding the attitude. So I think that that is part of what is going on here. And Nussbaum's work promotes dignity and imagination and empathy as a way to promote flourishing, and that's something I think we can learn from here. Also, the IRS regarded SRS as an immoral form of self-mutilation, citing articles that appeared in religious journals, and I don't have to stop. Citing articles that appeared in religious journals that would categorically deny the use of SRS for gender identity disorder. So we'll skip that, skip that. All right, so I just have to conclude. If recognition of the human need to be treated with dignity requires breast reconstruction for a cancer patient or a wig for a bald cancer patient, it also requires that the internal states and stories of transgendered person not be ignored, and requires that society examine irrational heuristics of projective disgust.